Tantor Audio, a division of Recorded Books, presents Demand the Impossible, One Lawyer's Pursuit of Equal Justice for All, by Robert Tsai. Narrated by Kaipo Schwab. So, after all, maybe the South, the nation, and the world are in dire need of creative extremists. Martin Luther King, Jr., April 16, 1963. Introduction. On the morning of April 24th, 2017, Stephen Bright arrived at the most powerful court in the nation for the fourth time in his career. His client's life was at stake. 3 times before, Bright had argued in front of the U.S. Supreme Court, and all 3 times he had won. Could he pull it off one more time? We'll hear argument first this morning in Case 16-5294, McWilliams v. Dunn, announced John Roberts, Chief Justice of the U.S. Supreme Court, promptly at 10 a.m. As the presiding justice, he sat in the center of a raised bench, carved from mahogany, with the other 8 justices fanning out in either direction. Constructed in 1935 in classical Corinthian style, the building was designed to be an awe-inspiring testament to equal justice under law, a phrase that is emblazoned above the main entrance. Bright, who represented James McWilliams, stood up and buttoned his jacket, one that he had picked out in a thrift store. For 35 years, Bright had led the Southern Center for Human Rights, SCHR, a nonprofit based in Atlanta that rendered legal aid to people under death sentence and pursued the reform of incarceration policies. Bright had spent decades trying to fulfill the promise of Gideon v. Wainwright, the landmark 1963 Supreme Court decision that established the right of counsel for poor people. It was a worthy and ambitious vision, but one that had never been fully realized. Bright's work had focused on improving the criminal system of the Deep South, where the politics of mass incarceration had exacerbated the legacy of slavery and Jim Crow, producing a dehumanizing form of unequal justice. America had changed so much since Bright's first Supreme Court argument back in 1988. Then he could work with the remnants of the fabled Warren Court, a series of legal precedents established between 1953 and 1969, when Earl Warren oversaw the court's work. President Eisenhower appointed Warren, former Attorney General of California, to the court at a crucial historical juncture. His liberalism and statesmanship helped break a logjam over the constitutionality of racially segregated schools. With Warren at the helm, the High Court not only produced Brown v. Board of Education of Topeka and supervised the dismantling of legal apartheid, but also issued decisions protecting the right to vote and ensuring that people charged with a crime would be treated fairly. Even as the court lurched to the right over the years, Bright still achieved a remarkable win rate as a cause lawyer. Each of the previous times he argued in the highest court of the land, he had persuaded enough of the justices to come together and give a condemned man another chance. When it came to reading the shifting sands, Bright displayed an instinct for discerning the most attractive arguments that could be used to cobble together a consensus. He knew that compromise was unavoidable, given the generally cautious nature of most judges. Flexibility over strategy was essential because saving clients had to be the priority. Human beings were not just means to an end. Yet he also cared about pushing the law in the direction of justice, so other people in desperate straits could also benefit. While Bright was certainly skillful in front of appellate judges, those who knew him best felt that it was before a jury that he truly thrived. Bright had a knack for conveying how broken people could fall through the cracks in the criminal justice system, and his barely contained sense of outrage and fierce attention to detail earned him the respect of judges and adversaries alike. He had earned his reputation by taking cases that no one else wanted, representing clients that society had long ago discarded. By plunging himself into his client's whole life and pulling out all the stops, he had won cases few lawyers would dare tackle. Even so, McWilliams' appeal faced long odds. Unlike his past trips to the Supreme Court, Bright did not have a compelling story about official misconduct to tell. There was not a racist district attorney who manufactured unrepresentative juries. Instead, in representing McWilliams, Bright was pleading for the life of an intellectually disabled black man convicted of killing a convenience store clerk during a robbery. These kinds of cases were made even more difficult because bigotry and suspicion rendered the issue of intellectual disability volatile. There was no telling whether a judge or juror would see such a condition as a reason for mercy, or instead as an excuse to treat a person more harshly. Did it make someone less morally culpable, or was it proof that the individual represented a future danger? Bright had come to Washington to tell the justices that even when someone has been found guilty of a brutal and senseless crime, an accurate sentencing process still mattered. Whenever evidence suggests that a defendant might have brain damage, basic fairness requires he be given a mental health expert. As his time ticked away at oral argument, Bright realized he had to somehow hang on to the liberal justices, who had dwindled to just a handful, and find a way to convince someone else to join the fold. If he could manage that, he might still eke out a ruling that would extend his client's life for a few more months and help other people with a potential intellectual disability. If he failed to scale that mountain, then brain damaged or not, McWilliams would lose his life. Stephen Brooks Bright entered the arena of death penalty politics at a critical moment in American history. Bright came of age during the tumult of the late 1960s and early 70s. As a teenager, he heard the pleas for justice at home and abroad, as fellow citizens spilled into the streets to demand an end to racial segregation, and students occupied campus buildings to protest American imperialism in Southeast Asia. At first, his tool of choice consisted of social activism. But as America's conservative mood deepened, Bright became disillusioned with electoral politics and instead became a convert to legal liberalism, believing that judges had to curb democracy's excesses by enforcing individual rights. Trained as an advocate for the poor, he took up the cause lawyer's primary instrument, harnessing the power of the courts to spur social change. In that respect, he resembled radical lawyers like Thurgood Marshall, William Kunstler, and Bryan Stevenson. Like his counterparts, Bright sought to unleash social change by representing unpopular clients, reviving legal principles from within the political order, and leaving behind organizations to carry on the work. Bright and his allies began their fight for equality under the law at a time when headwinds were the strongest and changes in criminal justice policy were widening existing inequities. Regardless of party, most politicians in the 1980s and 90s proved to be largely indistinguishable in their demands for more statutory offenses, longer sentences, and expansive use of the death penalty. Democrats like Ed Koch and Bill Clinton sounded exactly like Republicans Rudy Giuliani and George H.W. Bush as they worked across the aisle to push ever harsher criminal laws. The war on crime turned into the war on drugs, and the war on drugs eventually rolled seamlessly into the war on terror. In the crusade against a seemingly endless stream of social misfits, legislators and judges found novel ways to limit access to justice. Often working in tandem, elites built an imposing jurisprudence of dread, a set of laws, doctrines, and concepts based on outsized fears of strangers and intended to facilitate severe punishment policies. America's incarceration rate exploded in these decades as the country became the world's leader in using criminal laws to deal with a wide range of social ills. Resort to capital punishment also expanded. Jonathan Simon has described the political sentiment that drove policies as lawmaking without pity, reflecting an overinvestment in penal laws, prisons, and the rise of a waste management model of handling human beings convicted of criminal offenses. The death penalty represented the ultimate means of disposing of unwanted lives. Through most of the 20th century, the prison population hovered around 200,000. But starting in the mid-1970s, the incarcerated population leapt to over 1.5 million. Today, America accounts for 22% of the entire world's prisoners, even though it makes up only 4% of the world's population. The United States is unlikely to be the most crime-ridden country in the world, but for the last 50 years, its policies have been driven by a perception that social disorder lurks around every corner. Bright emerged on the scene as a cause lawyer just as these cascading policies crashed hardest on poor people and racial minorities. Although America has been killing its own people since the colonial period, capital punishment was refashioned into a tool of racial control. Eager to preserve white order, slave-holding states made the rape of a white woman a capital offense, and between 1930 and 1972, 89.1% of the people executed for rape in the United States were black. Nearly all of these sentences were carried out by former Confederate states. Even after explicitly racist death penalty laws were struck down by courts or repealed by legislatures, significant racial and regional disparities remained. Like many Americans, Bright had not spent much time thinking about capital punishment because he assumed that the Supreme Court's 1972 decision in Furman v. Georgia, striking down death penalty laws as arbitrary and capricious, had ended the punishment once and for all. Yet within the next few years, 35 states responded to Furman by enacting new death penalty statutes. Then came the anguished pleas for help from incarcerated people after the Supreme Court reinstated the death penalty in its 1976 decision, Gregg v. Georgia, deeming the practice permissible so long as a state enacted procedures to constrain sentencing decisions over life and death. State officials wheeled back out electric chairs that had been decommissioned and covered in dust. Some prosecutors rallied to the pro-death penalty banner as a way of making a name for themselves. Death warrants stacked up high. Few attorneys had any real expertise trying capital cases, and volunteers who kept an eye on these troubling developments scoured the country for anyone brave enough to lend a hand. Bright took on 3 cases right away. What he saw infuriated him. Inexperienced lawyers appointed for the poor presented little or no mitigation evidence to try to convince juries to spare their clients. In a number of cases, defendants were tried and sentenced to death in a day or two. The brief filed in a subsequent appeal might be bare bones, lacking arguments or even citations to key cases, all evidence of a slapdash effort. Bright's experience scrambling around the country trying to obtain stays of execution for people who had been wronged by their own lawyers would lead him to embrace the correction of these problems as his life's mission. These days, cause lawyers are thought to be advocates who run to court and demand injunctions to halt abortion restrictions or immigration policies. That misconception is more likely due to the fact that by the mid-20th century, civil rights activism had splintered, with some of its most visible activities outside of the criminal justice realm, rather than because the definition of cause lawyering inherently excludes criminal matters. Few today remember that the NAACP had originally been established in the wake of race riots in Springfield, Illinois. A white mob tried to lynch 2 black men detained in a local jail, and, when their plans were thwarted, began a rampage throughout the city. Appalled, suffragists, labor reformers, socialists, and clergy came together to promote a new abolition movement, to eradicate caste or racial prejudice, and securing justice in the courts. In 1910, the NAACP handled its first major legal case by defending Pink Franklin, a black sharecropper sentenced to death for killing a police officer in South Carolina. Franklin had gotten into a shootout after police came to arrest him for failing to show up to work. He and his wife had to escape a lynch mob before the NAACP arrived to help. The NAACP continued its anti-lynching efforts in the 1920s, and in the 1930s represented black defendants accused of serious offenses against white victims, where the sentiment for mob justice ran high. Only as the organization's resources grew did more of its energies go toward dismantling segregated workplaces and schools. Called to the South in 1982, and believing himself to be working in this tradition, Bright threw himself against the gears of a restarted killing machine. If the rush to incarcerate and execute were not reversed, he believed, the many injustices would eventually delegitimate the legal system and bring the entire thing crashing down. What Bright lacked in pedigree and powerful patrons, he made up for through a punishing work ethic, a wicked sense of humor, and keen insight into the human condition. He went on to become one of the greatest lawyers of his generation, arguing 4 times before the U.S. Supreme Court, reviving a dormant organization established by ministers during the Civil Rights Movement called the Southern Prisoners Defense Committee, and renaming it the Southern Center for Human Rights, and shining a spotlight on a host of unconstitutional practices. Most striking of all, Bright's devotion to legal liberalism fostered the development of a distinctive method of cause lawyering, one that could be passed on to the next generation. It all came back to the central idea of human dignity. This concept has many meanings in the law, but in Bright's hands the idea meant, first and foremost, that state-sanctioned killing and mass confinement of human beings raise moral questions. If a system of punishment consistently marks the poor or other disenfranchised groups for punishment, then that system cannot be reconciled with our nation's fundamental values. A truly humane approach to punishment, by contrast, enfolds the values of equality, fairness, proportionality, and rehabilitation. As Bright would often say, such a system of justice treats a person accused of a crime as more than the worst thing he has ever done. The Brazilian educator Paulo Freire once observed that a person is solidary with the oppressed only when he stops regarding the oppressed as an abstract category and sees them as persons who have been unjustly dealt with, when he stops making pious, sentimental, and individualist gestures and risks an act of love. For Bright, an ethical model of lawyering counteracted the dehumanizing aspects of the American criminal justice system. He felt that the lawyer-client relationship could be transformed into an act of self-discovery for both parties to it, and more ambitiously, that connection could be an engine for social re-examination. If the adversarial process was central to our nation's deepest values, and indeed represented a key method of contesting those very values, then a trial could, in the right hands, serve an agonistic function by affirming those principles for all to see. In this sense, fearlessly demanding justice on behalf of the whole person and pursuing an end to unjust punishments went hand in hand, for the two projects together helped build a broader culture of equal respect. Treating despised members of society as worthy of a vigorous defense restored their dignity. In turn, laying everything on the line to show a community that a person was more than the sum of bad things he did in his life was the greatest act of love a lawyer could muster. This was why nothing enraged Bright more than hearing about incompetent lawyers and indifferent judges. Where others would indulge excuses, he saw violations of constitutional rights, a stain on his profession, a continuation of the age-old pattern of the wealthy getting their way and the poor getting the shaft. He collected such betrayals as if they were America's scars, true stories of sleeping lawyers, drunk lawyers, lawyers who despised their own clients so much they did almost no work on their behalf, and begged jurors to put them out of their misery. And he railed against judges who had become so numb to the daily grind of processing cases that they were no longer capable of distinguishing between inconvenience and injustice. Born in 1948, Steve Bright grew up on a farmhouse in Danville, Kentucky, with his 3 siblings. Their father, Robert, who had inherited the farm from his father, raised cattle and grew tobacco. Patricia, their mother, made sure that the children were fed and cared for. In his spare time as a teenager, Steve Bright wrote for the local newspaper, the Advocate-Messenger. The job allowed him to get into everything. It also gave him his first taste of the political world. Bright had been fascinated by politics since he was a child. He loved everything about it: the energy of the crowds, the soaring oratory of the most practiced speakers, and the way that well-formed sentences could move people to action. He was energized by the first political rally he attended at age 15, when Democrat Edward Ned Breathitt spoke at the Danville courthouse during his campaign for governor. Breathitt, an underdog who offered a progressive view on civil rights, went on to win that race. After finishing at Boyle County High, Bright traveled down to Lexington to attend the University of Kentucky. It is difficult to overstate just how hopeful many young people felt at this time. Starting in 1961, brave Freedom Riders had descended upon Southern states. A biracial coalition of students led the way through Freedom Rides, as organizations such as CORE and SNCC organized sit-ins and demonstrations to help galvanize the country to see the inherent brutality of racial segregation in America. All of this had sparked a moment of moral reckoning, leading Congress to enact the landmark Civil Rights Act of 1964. After defeating conservative Barry Goldwater for the presidency in a landslide, Lyndon B. Johnson promised to build the Great Society. Yet many Americans, especially the older generations, grew weary of the upheaval associated with the rapid pace of legal transformation. Involvement in Vietnam also increasingly divided the country, as young people were forced to bear the brunt of Cold War policy in a faraway land. Bright had entered college with a plan to become a journalist. By his sophomore year, he decided to shelve his original plan. He switched to political science and threw himself completely into student government. After being branded by the school paper as an individual with a very unenlightened attitude, Bright lost his bid for the student government vice presidency in the spring of 1969. A year later, he campaigned on a platform for radical change in student government, earned the endorsement of the paper, and won the presidency going away. He made an early misstep by supporting the playing of Dixie at sporting events, but also publicly urged additional integration efforts. Although the university had desegregated after Brown v. Board of Education, it remained a mostly white institution into the early 70s. Bright had always understood this issue more intimately. In Danville, his parents had participated in efforts to desegregate schools and businesses. As a member of Sigma Nu, Bright gave speeches to persuade the fraternity to admit black members, but his efforts fell short against a traditional selection process that allowed a single objection to keep someone out. The truth was hard to swallow. It would take more than a few speeches to do anything about systemic racism. Everything changed for Bright and so many other members of his generation when the National Guard opened fire on unarmed students at Kent State University on May 4, 1970. President Nixon said of the killings that, "When dissent turns to violence, it turns to tragedy," while his pugnacious Vice President Spiro Agnew blamed "Tomentos exhibitionists" on college campuses. The administration's callous response to the Kent State massacre, coupled with its extensive efforts to undermine anti-war protests, sparked additional marches and sit-ins throughout the country. At the University of Kentucky, students occupied an administrative building while university trustees met, calling on school officials to denounce the Nixon administration's undeclared war in Southeast Asia. For as long as possible, Bright sought to play a bit of both roles. as a mediator to facilitate dialogue and diffuse crises, but as an activist when it came to voicing the grievances of his generation. Yet he would learn that the ground could shift under your feet during a struggle for social justice. When that happened, you might have to take one side or another, or else get out of the way. After an Air Force ROTC building on campus was set ablaze during a protest, Governor Louis B. Nunn declared martial law on the campus of University of Kentucky. State police cleared campus grounds and imposed a curfew. The next day, guardsmen in riot gear deployed tear gas against students and arrested several protest leaders, including Bright. Governor Nunn justified his crackdown as part of an effort to resist the paralyzing effects of violence, intimidation, and anarchy in American society. The dangerous people here are not the students, Bright declared. Instead, he criticized Nunn for exploiting the students to save a dying political career. A majority of voters backed the governor's strong-arm tactics. Bright lent his name to lawsuits that challenged the governor's emergency order and university policies, but lost in court. In turn, the university filed disciplinary charges against him and several others, seeking to expel dissenters. Only by obtaining the services of a talented third-year law student did Bright escape being drummed out of school. Bright's encounters with the state radicalized him. He could not stop the university from rewriting the disciplinary code to make it easier to sanction students, but he castigated school officials for failing to recognize the student as a human being and rejecting trials by one's peers. Feeling powerless, he told trustees that when we deny the rights of a few, we have denied everyone their rights. "I want to get out of the South for a while," Bright told people. His goal as a student leader was to make the university treat students as human beings rather than machines. He had learned to confront power, winning some battles and losing others. He also now knew how to mend political relationships that had frayed. Most important of all, he had started to formulate a critique of the state, how law and politics can degrade human beings and lock everyone else into a cycle of recrimination and violence. A possible career in politics became far less attractive to Bright when Democrat George McGovern lost his bid for the presidency in 1972. After entering law school, Bright had taken a leave to work for McGovern's campaign. McGovern wasn't just an anti-war candidate. At the time, he had seemed like the best hope for a national revival of humanistic politics, but his resounding defeat by Nixon led Bright to turn to the prospect of pursuing social change through the courts. The inspirational radical lawyering of William Kunstler and Leonard Weinglass loomed larger as political heroes waned. As much as he found law school out of step with the needs of the times, Bright returned to the University of Kentucky and completed his legal education. After a stint at the Appalachian Research and Defense Fund advocating for the poor, Bright relocated to Washington, D.C., to work for the Public Defender Service for the District of Columbia. Originally operating as a legal aid society, PDS was charged with a new mission in 1970 to satisfy the Constitution's guarantee of providing defense counsel for people who cannot afford an attorney. In 3 years, Bright worked his way up from misdemeanors to felonies. Most of his clients were African American, as were the jurors in the cases that went to trial. He learned the stark differences between urban poverty and the kinds of deprivation he had seen in rural Appalachia. Bright discovered that what truly mattered in changing his clients' lives was doing the grueling social work, especially in getting youthful offenders into the right program rather than incarceration. In a place filled with incredibly personable and dedicated attorneys, Bright built a reputation as a talented and well-prepared public defender. When he had a trial, word would spread like wildfire through the courthouse. Attorneys and staff would fill the back of the room to watch him in action. These years didn't offer the chance to litigate complicated constitutional issues, just the occasional search and seizure question. Critically, however, Bright did have the opportunity to hone a brand of client-centered lawyering instilled in him by his colleagues. In court, Bright focused on ensuring...
Sample complete. Ready to continue?